Welcome to another edition of the MMK Show, and this month the show is brought to you by Loza Loza, who is one of our, or the preferred law agency for trademarks and patents. And we've got Tina Loza herself with us today to answer all of your questions related to trademarks and patents. Hi, Tina. Welcome to the show. How are you doing today?
Hi, Tina.
Hi, Tina.
Nice to see you.
How are you? I'm here. Third word.
Okay, there's a slight delay. Tina was having
It's cutting up a lot
earlier.
Yeah, I'm so sorry for the delay, and I'm sorry that my connection doesn't seem like it's that good because I'm hearing half words.
Okay.
It's coming through good now. It's good now.
Yeah, we can hear you clearly.
Okay, let's talk quickly then.
Okay, so this is an Ask Me Anything session, and everybody watching, if you have any questions about trademarks, patents, you can post your questions in the comments, and Tina will be answering your questions. And we have some questions for you, Tina, as well, because there are always people who are new in the group who are applying for trademarks for the first time.
Sure.
So we've got some basic questions for you as well. So Mark, do you want to get started?
Yeah, look, just to get started, Tina, can you just explain to people who don't really understand what is an actual trademark? Very simple question for you.
That is a great question. I love it. I like that you're starting me off easy today. So what's a trademark? Trademark is a source identification. So any kind of word or symbol or color or sound that you use in connection with your goods or services is a trademark. And easy international examples of this are the golden arches, the M for McDonald's. Okay, you see the M, you know that you're going to get a average cheeseburger. So what happens is a trademark, you know the source and the good that you're going to receive by seeing or hearing a trademark. So that is what a trademark is. For the purpose of Amazon sellers, it's what you're branding your goods with. So, anything, the name that you're calling your thing, the item, the name of the Amazon brand seller or the seller name is usually your trademark. Usually they match up.
Okay, fantastic.
So that's a kind of an easy way to think about it. If you're selling clothing, it's probably on the tags. If you're selling cups, it's probably on the bottom of the cup or on the packaging. Those are some easy examples of what you might think of as a trademark.
Okay, thanks for that, Tina. Now, the second question is, can you explain the benefit of having a trademark, and in particular for an Amazon seller?
Sure. So just general benefits, I'd really like to touch on this because believe it or not, Amazon is not the only place that there's really a lot of benefit from having a trademark. You are giving notice to the country and often to the entire world if they're searching the registry that you have rights to this name, and that you will stop third parties from using the same or similar mark in connection with identical or related goods or services, right? So notice is a huge one. Is someone does a search, they're able to find you very easily on the trademark office website that you are registered or pending trademark, and so they probably won't get that trademark. They'll think of another one. Another huge one is federal court jurisdiction. So you're going to be suing in federal court if there's an issue. But the big one for Amazon brand sellers is Brand Registry, right? So the ability to enroll in Brand Registry, you get certain rights with Amazon, you get enhanced brand content, you get the ability to access certain counterfeit tools that they have. They are always running AI on everything that is being sold. So things are being stopped that you might even not realize are being stopped by the millions every day. And this is something that I found out recently. I was at a trademark conference, and Amazon actually had a little meet and greet for all of the IP Accelerator firms, which was really fun to meet all the other IP Accelerator firms, but also to learn some of this firsthand knowledge from Amazon about how they are helping Amazon sellers who are enrolled in Brand Registry. So those are some that you can think of. Also, registered trademark, Instagram and Facebook have benefits and better ability to shut down infringers if you have a registered trademark. Customs, you can record your registered trademark with customs, and customs will stop it from coming into the country. There's so many tools that are available for sellers who have registered trademarks. It just opens up a huge ability to stop infringers, which I think is the biggest problem for sellers.
So Tina, what is the process of applying for a trademark, and what are the timelines for trademark approval? And there's also brand registry approval. So how long does that take once you have applied for a trademark?
Right. So to file for a trademark, I think it's pretty straightforward, or at least I think it's straightforward. You would contact me or another law firm, but I'd love for you to contact me. Once we engage you as a client, then we perform a preliminary trademark search to make sure that if we file your trademark, you have a pretty good shot at getting it. So I'll give you a risk assessment. I'll do a search. I'll say, hey, listen, I think there's a low risk associated with filing for this mark. I think there's a high risk. You should choose another mark. If I tell you it's a high risk, believe I'm not doing it for fun. I really want to file a trademark for you. So if I say something is high risk, I would recommend that you really choose another trademark application. Once I file your trademark application, it will usually take about 6 months before the trademark office will even look at it. Right now, the timeline is 6 to 8 months. I was sitting with the director of the PTO for one of the directors in the offices, because now there are several in the US. And yeah, I mean, it's not looking like it's going to get any better. So it's at least 6 months before anybody is looking at it, right? And then usually you will have a registered trademark in about a year. If we file a use application, there are 2 different kinds of applications you can file: use and intent to use. Use means you're already selling the goods in commerce. Intent to use means that you're not yet selling the goods in commerce. If you're not yet selling the goods in commerce, your mark will not register until we show your use, which means until we show that you're selling the goods in the United States. In terms of Amazon Brand Registry, once I file, I report the mark to Amazon, like same day. We're telling Amazon, hey, we filed this trademark, here's the serial number. Amazon says that it's a 14-day turnaround. Told us this will very soon be immediate, like within 48 hours, if an IP Accelerator firm is filing it for you. So that is coming soon. I can't promise that that's happening yet, but I do think it's happening pretty soon. And it might be, like, we still are telling our clients 14 days. It's possible that if you tried before the 14 days, it might go through. But I don't like to advocate for it, because what happens sometimes is it gets caught up in a weird loop at Amazon. So I try not to get anybody too excited about it, but it's very soon going to happen that it's going to be pretty instantaneous, like 24 to 48 hours. So I think that's good news. Even though the 2 weeks was already very speedy, I thought, I think it'll be wonderful when it's pretty quick. As soon as Amazon sees it, it's going to be a pretty quick.
Wow, that is amazing. And like, if it happens in 48 hours, and I was going to ask you, and I was going to say that 2 weeks is pretty quick. And are there any situations in which, maybe it's delayed? Like, why would it be delayed? Is there, something that sellers need to be aware of, if all their, documents are not complete, or are there any reasons that might be delayed?
If you use another firm, there is any more than 2 weeks.
Okay.
Did you get that? It cut out for me a little bit. It's an IP Accelerator firm. There's no reason why it should take longer than 2 weeks. It's it's consistently seeing it go through no issues. If there is an issue, it's because of a product issue, an ASIN issue, something like that. It has nothing to do with the trademark.
Okay, fantastic. And
it's been going easily.
Okay, great. And so if it comes through in 48 hours, that's like breaking news for Amazon sellers over here. So guys, you heard it here first. You heard it from Tina Loza.
I'm afraid
MMK Show.
So it's coming I mean, they told us it was going to happen soon. Now, soon on Amazon time, I don't know, but I'm telling you that it is going to happen. It is going to happen. 2 weeks is still very fast, though, I think, and they're very consistent about it. I haven't had any issues with it happening pretty steadily in that way. So I don't want you guys getting too excited, but it's coming soon that you'll have access very quickly.
Awesome. Okay, we've got one question from YY10. I have a brand registered with Amazon. What will happen if the brand is not trademarkable?
Well, if it doesn't end up getting registered with the trademark office and it goes abandoned for whatever reason, then Amazon will eventually remove it from Brand Registry. And we have been seeing this happen pretty consistently. So once a mark is fully abandoned without the ability to petition to revive or anything like that, they will pull it from Brand Registry. So sometimes there are options related to whether, why it's not trademarkable. If it's because of likelihood of confusion, we'd have to look into that a little bit more. But if it's because of descriptiveness or other issues, I might have some advice around that. So I would just have to see, the prosecution history or what happened in the records, so they figure out how to help you stay on live at the PTO so you can remain enrolled in Brand Registry.
Okay. So can I have the same brand name as someone else in another country or even in the same country?
I mean, technically, you can have the same trademark as somebody else so long as the goods and services are not identical or related. So a person can sell, let's say, cosmetics with the same trademark as someone who's selling car parts, right? Because consumers wouldn't believe those two things come from the same source. So why would that be a problem, right? So that's the way the trademark office looks at it. As far as I know, Amazon is dealing with this issue. It was a question, if there's two sellers with the same brand name, how are you dealing with this? They didn't give us a really good answer. So I think that they are letting both sellers stay on. It will take a little bit of advocacy on the part of the sellers to explain the issue to Amazon. So that is just something that you should expect. My advice would be to try to seek out, seek out a different trademark if you have the ability to choose another trademark that is not in conflict with another seller. I don't think that the problem is as much of a problem in other. So if you're trying to sell in another country, for example, if it's two different countries that have the same name, that's not as problematic. But if both sellers are staying with the same name in the United States, that might trigger some issues.
Yeah, and I suppose
one question for you, Tina. Can you explain the different classes and how they work? And is it necessary to trademark in every class if I have lots of products?
Yeah, the class system is one that is developed by most trademark offices, and it's a very handy way for them to charge you for different things. But essentially, every good or service belongs in a class. So electronics are in class 9, clothing is in class 25, paper goods are in 16, jewelry is in 14. So you kind of have an idea of what that looks like, right? So if you're selling goods in multiple classes, you can file in multiple classes, and the filing fee in each class is $350. So you can imagine that this adds up. If you file in 2 classes, you're looking at $600. If you file in or whatever, $350, that's $700. If you file in 4 classes, you're looking at $1,400. There's no break in that. That's all from the trademark office. Now, Amazon doesn't. Amazon's like, hey, just file in 1 class if you want to, and we'll let you be on Brand Registry for anything that you sell. So from an Amazon perspective, if you are selling drinkware and you're selling paper cups and napkins and other things that happen to be in another class, and you're selling headphones, happen to be in another class. Like let's say you're selling all three things. You could just choose to file with your most popular product, for example, and Amazon will let Brand Registry, you'll be on Brand Registry for all of the things that are under that brand. The trademark office, though, I mean, ultimately, why are we filing a trademark? What is one of the reasons we file a trademark? Is to stop third parties from using the same or similar mark in connection with identical or related goods or services. So if you just file with your drinkware, for example, and someone else comes along and starts using the same trademark in connection with their headphones, but you're selling headphones, you just didn't file in the class for headphones, well, they don't know that. So the notice function is gone. And so you might have a more difficult time enforcing your mark against that person. And so that is the consideration. If you're selling completely unrelated goods that don't happen to be on your application, well, is that something that's going to bother you? And you do have some common law rights in that situation, but it's not as strong as the federal rights. So that's, I think that there's definitely a balance that should be had. And, you need to just think about the return on investment, whether it's worth it for you to file in another class, whether you're making enough money in that class to justify the expense.
Right, thanks.
So let's just take this question from Vandana before we move to the next question, Kevin. Vandana is asking, if a trademark is registered but not in use or dormant for a period of time, can I apply for it?
I mean, if it's still on the registered and it's considered live, but they're not using the mark in commerce, then they still will be cited against you. It is a live mark. There are tools available right now. The Trademark Modernization Act was passed, I think it was late last year. And so there are tools to get rid of what is called this dead wood on the registry, because there are lots of marks right now that are registered that those companies went out of business. They're not selling those goods anymore. They filed the description of goods very broadly, and they're not selling even one of those things, or maybe they just sell one thing and they have 80 things listed. So there are tools that we can use right now to get rid of that mark if we need to. But it will not be the easiest path forward, right? We have to we'll have to do some litigation work it's not really litigation, but we will have to use the tools that have been afforded to us by the Modernization Act to try to get rid of that mark before you would be able to successfully get your mark through. What I could recommend in that situation is filing your mark if it makes sense, and then wait and see if we actually get a rejection. And then at that time deal with the situation. But you have to be comfortable with the risks associated with perhaps never getting your registered mark. That is the downside. So if I'm thinking, okay, do I want to choose a mark right now that potentially I might not ever get, or do I want to choose a mark that's free and clear, or as free and clear as I think it might be, I would choose the easier path, especially if no money has been invested yet.
So this is a follow-up question. So if a trademark is dormant, assuming the trademarks have to be renewed each year, does that mean it's available for others? Trademarks don't have to be renewed, right?
Trademarks do not have to be renewed each year. They are renewed between the 5th and 6th year after registration, between the 9th and 10th year after registration, and then every 10 years thereafter. So if a trademark, if you're not finding use of a trademark, and then you see that they're not renewing the trademark by the end of the grace period, then that mark will maybe go abandoned. And when it goes abandoned, that could no longer be used as a cite against your mark. But you might have to wait to see whether that mark is going to be renewed or not. And there's a tab when you're looking at the at the trademark. If you look up a trademark and you're on tests and you click on TSDR, there's a maintenance. You can see when the period is going to be finished by which they have to renew, and you can see when the grace period is over as well. So if you have a situation where something is running out on its grace period and that person is not renewing their mark and they haven't, then you might be fine.
Okay. Kevin,
Tina,
I've
got one more question for you, Tina. Do you recommend that Amazon's... Sorry, can you hear me? Do you recommend that Amazon sellers trademark in each country they are selling in, and also in the.
Yes.
Can you hear me?
Time lag, I think.
Yeah.
You're cutting up a bit, but yes, I mean, my answer to the first question is yes, you should trademark in every country that you're selling in, because Amazon now has the program in a ton of countries. They have IP Accelerator firms in a ton of countries. There's tools available for you to do that. And so, yes, I think that if you are selling in other countries, consider filing.
And especially in the country that your supplier is supplying you from as well.
Yeah, potentially, because they could be selling your same goods in the back door, and somebody else could be making a profit in that supplying country.
Great, thanks.
You're welcome.
Okay, so Tina, Amazon allow me to have brand registry before the trademark is approved, but what do I need to provide to Amazon in that case? So once it's the 14-day, what do I actually give Amazon? Can you explain to people what they get or give?
I don't know that piece as well, because I only take you through the trademark. So what happens is once I report the serial number to Amazon, then you go in and enroll. I don't even think that you have to provide images. I'm not sure exactly what you have to provide to Amazon to enroll, but I don't think it's complex. So it's a pretty easy form. Megla, I think you have that email that I send out after I file the trademark with the exact with screenshots essentially of what Amazon will ask. If you want to share that with your sellers, I'm really comfortable with that. That might give you some idea of what Amazon's going to ask you, so that you're ready to go the minute you can.
Okay. Yeah, and I don't think there was anything that I had to provide Amazon. It was just I had to go into Brand Registry and then just click, and yeah, it was just instant. But it did take some.
Yeah.
Yeah.
Yeah, and
It
you
should be
provide the serial number for us, don't you? You actually provide Amazon the serial number.
I give you everything you're going to need to be successful. So you'll know, like, you need to know whether we the word mark or design mark. You're going to need to know your serial numbers. So I definitely give all of the information from my end that you need. And then Megla, I know you have those screenshots of what the page looks like. So, feel free to share that as well. But it's not complicated. It's not a hard thing. I don't think Amazon is trying to trip you up. I know that there are other places where it's more difficult. This is not one of them.
Okay. So we've got a question from Vandana. Can a competitor use my trademark, name, and brand design in another country?
Can a competitor use my trademark in another country? Yeah, they can. Unless you're registered in that country, each country has their own rules, their own rights, their own trademark registry. So certainly a competitor can use your same trademark, everything in another country, and not, potentially not have any issues with you. And it's upsetting because sometimes I do represent some pretty famous brands, and we will see our brands filed exactly the same way in other countries. And in those cases, we have watch services, and we are able to go after those brands. And because there's such a large, there's a large brand that owns hundreds of marks, it's a little bit easier to enforce in those situations, but it's costly. And so when these things happen, it's definitely concerning, which I think brings us back to Kevin's question, which was, should I file in every country? Well, yes, that's why. Every country that you think that might be a problem. So your supplier country, any countries that you happen to sell in, all of those are good ideas.
So Tina, how much does a trademark actually cost to, obviously to lodge, and then your fee on top?
Am I frozen?
No.
Sorry, Marg, I missed that.
Oh, did you miss it? Okay. Yeah. So how much does it cost? Good. You got me? How much does it cost to lodge a trademark, and how much are your fees?
Yeah. So the filing fee with the trademark office is $350 per class. We've talked about the classes already. My fees are $900. I charge, I perform a preliminary trademark search. I report the results back to you with a risk assessment, and then I prepare and file the trademark application, and I report to Amazon, and you can call me 72 times, and everything is included in the $900. So if you know, it's a flat fee. It's very straightforward. No one has ever called me 72 times. I'm happy to say. But it is a flat fee. So if you file one trademark in one class, you're looking at $12.50 total.
Okay. What about if you do intent to use? If you only file for intent to use, is there another fee?
It costs exactly the same thing at the beginning, so $12.50. The difference with intent to use is at some point we're going to have to show that you're using the mark in commerce. That really necessitates the filing of a statement of use. It will be about a year from filing. And when we file the statement of use, there are additional fees. And if it's one mark in one class, we're looking at $500 total. That includes the filing fee.
Okay, thank you.
Okay.
And
So
Tina,
we've got a question from
one
Christine.
more question. Can I just ask just quickly, Tina? It like what I said before about in lots of countries, is if I did the Madrid protocol, is that a cost saving instead of doing one for every country? Yeah. Is that a cheaper way to go?
Depending on how many countries you want to file in.
Yeah.
The Madrid protocol, it could be a cost savings, and we use the Madrid protocol if it would be a cost savings. It just depends. Sometimes if it's just one country, it's actually cheaper to file direct in that country. There are countries that are not in the Madrid protocol, so we have to file direct in those countries. But if it's like we're filing in the EU and China and the UK and Japan, and if we file in like a few countries, then yes, the Madrid protocol is usually a good idea.
Yeah, because I only asked that question because many of the sort of sellers would operate, in various countries, especially Amazon sellers operate in various countries through the global selling, and so if they had a US trademark and then suddenly said, "Oh, okay, I'll go into Canada." And then I'll go to the EU. Each time, obviously, there's an expense. But if that was your intention, so to go for the Madrid protocol at the beginning, if your intention was to globally sell, would work out a lot cheaper.
Yeah, it definitely would. It would be more cost effective to use the Madrid protocol, depending on the countries we're going to file in. And I think it's just important to communicate that with your attorney and be like, hey, I want to file in several countries. It will still be costly. The Madrid protocol is still costly, but it is more cost effective. It's easier for us to file it that way too. So it's definitely something that we would use that option if it's a cost savings for the client. We always opt for the one that's more cost effective. In this case, not only is it cost effective, but it's easier for us.
Yeah.
So it wouldn't make sense for us to not choose the Madrid protocol if we could use it.
Yeah, excellent. Thanks, Tina.
Okay, so let's address Christine's question. Can you sell a trademark?
Yes, you can. A trademark is an asset, and is an asset of your business. It's an asset just like a house is an asset, or any kind of asset of your business. Your goods are assets. Anything that you can list on your financials is an asset. So it can be bought or sold. You cannot sell an intent to use trademark, but once a trademark is registered, you can sell it. You can also sell it if you file a use application. Selling a trademark is called an assignment. So you're assigning your rights, your goodwill and your rights to the trademark to another person. And so you can only do that for use applications, because intent to use applications by definition have no goodwill associated with them yet. So if there's no goodwill associated with them, you cannot sell them. And the reason for that, the public policy reason, is if we could sell intent to use applications, you would have people doing what they do with domain names, buying thousands and thousands of trademarks just for the purposes of selling them, and extorting money from large corporations and other businesses who just want to have a regular trademark registered, right? So that's the reason behind it, the underlying policy reason.
Okay. So before we go on to the next question, I just want to share the document that you had sent over, for Brand Registry. So after the trademark has been, you've applied for the trademark, then how to enroll for Brand Registry. So this is the document that you had sent with, very detailed screenshots and literally step by step the entire process. So step one, go here. This is what I really love about, working with your company, Tina, that everything is just so easy and I don't need to, look for stuff and go here, there. Everything is like very well organized. And so this is the step, this is the process basically to.
Yeah, I really document it.
Yeah.
The connection is cutting up a lot, but yes, I see what you have posted and we do make it as easy as possible. It's intentional.
So this is step one. You got to visit Brand Registry, sign in, and then enroll your brand. And then I don't know if you guys can see the text over here, but then there's just this form that you need to fill in, enter the brand exactly as you want it to appear on your Amazon page. For example, test mark, a test mark, a test mark. So it's really important to have the case right? I mean, all trademarks are case sensitive, so you've got to make sure that it's exactly the way that you filed it. If it's all uppercase, then it should be all uppercase over here, right, Tina? It's very important to have the exact same format.
I don't know about the case. I can tell you that I always file in all caps, as do most trademark attorneys. It's pretty standard practice. It's more about spacing. And if you have weird characters or anything like that, the exact match has to be there. So if we filed it with a space between two words, don't not include the space at this time. You have to do it exactly.
Okay. Yeah, and then you have to select select United States because or the country where you applied. Enter the trademark information, including application number, and select whether the mark is a word or design. You can leave both these questions blank. I really like how you've got very detailed instructions about, what to fill in where, what to leave blank as well. So there are no questions. No one's going to come back to you. And then upload images of your product showing the trademark. And after you fill the form, click next. And then most clients are considered Amazon sellers only. Add your ASIN, select the relevant categories, and that's it. You're done. That's about it. And then just submit the form. That's it.
Tina, can you just explain the difference between a word mark and a design mark for people?
Yeah.
Yeah. So the word mark is just the words that are in the mark. There's no design element. So let's say that there's a heart or a star or some such thing in your trademark, but we just filed the words in the trademark, and that's considered a word mark. If there is a design mark has a design element. So there's a heart, or there's some kind of squiggly lines, or there's a swoosh. I mean, a design mark that I think everybody knows, obviously, is the McDonald's arches or the Nike swoosh. Any design mark any mark that you're going to use for Brand Registry has to have words in it. So if we file a design mark, first of all, the word mark is the best and broadest mark to file. So if we're filing a design mark, it's usually because there's some strategic reason to do so. And we'll tell you if we think there's a strategic reason to do so. But ultimately, that the design element is when you have that Nike swoosh that's happening, right? So the word is Nike, and then there's a swoosh. That's considered a design mark.
So Vandana has a follow-up question. Do you apply for word mark and design mark at the same time?
You can, but my advice is usually to file the best and broadest mark first, which is the word mark. You can do both of them at the same time, but if you have like limited budget, then always start with the word mark. That's the most important mark. It's broader. It's a better mark to have and own. So I would always start with the word mark, and then if you want to file for the design mark, you could file for that.
You don't have to actually have a design mark approved, do you? You can just have your name, and then that's your registered trademark. Yeah, I mean,
you don't have to at all. That's why I recommend.
Yeah, we've only got.
The word mark is always.
Yeah.
So she's saying, I'm asking because the two of them together would represent my brand.
Yeah, I mean, you may use them together. Like if you pick up a Nike box, it's going to have Nike with a swoosh on it. But at this point, I could see the swoosh and know it's Nike. I could see the word Nike and know it's Nike. So even though you might use them together, the mark that I would tell Nike to file first is Nike. And then I would say, okay, file Nike with the swoosh. Then I would say file Nike with the swoosh and the color. Then I would, that's the way you narrow a mark and you get yourself some more protection. But the best mark is just the word Nike. So even if you use them together all the time, it's better to just file the words.
Yeah. And I think if you're just doing Amazon, it's really just having a trademark per se to get your brand registry, unless you want to actually protect yourself out in the big wide world. Is that what you would say, Tina?
Mm-hmm. Can you repeat that just because you cut out a little bit?
Sorry. Yeah, no, I think if you're just doing Amazon, just having the word is probably sufficient without having the logo. I mean, it's different if you're going to be Nike and you're going to be selling in every country in the world.
I think so. I think it's sufficient, and it's broad. You can stop any infringer with your word mark, whereas if you file for a design mark, you're more limited in your ability to enforce your mark against third parties.
Okay. So Tina, you also help with filing patents, right?
Mm-hmm. Absolutely. My firm, we have patent and trademark attorneys, and patents protect new, useful, non-obvious inventions. So if you have a product that you've invented and you know that it's a novel product and you potentially want to file a patent for it, we certainly can help with that.
Okay. And what are the different types of patents, and what are sort of the benefits of each type?
Yeah, I mean, the two big kinds of patents that people typically file are utility patents and design patents. Utility patents protect the usefulness of an object, and design patents protect the way a product looks. So, for example, I mean, I could just this is a Hydro Flask water bottle, right? So the usefulness of a water bottle is to hold water. Maybe there's some patentable objects in terms of like the way that it's insulated or something. Make a utility patent for, but Hydro Flask came to me, I probably would file a design patent for this, right? Sorry, my son drew that rough on there for me. But if you file a design patent for the shape of the Hydro Flask, the design is novel, right? The way that it looks. It doesn't have to look like this. The water bottles come in many different shapes and sizes and different looks. And so Hydro Flask could technically file a design patent for the way that the Hydro Flask looks. So you can get patent protection for that. So those are the two different kinds of patents that you can file. I'm sure that there's, in terms of utility patents, there's also different ways you can file. So I'm sure people have heard of provisional patent versus non-provisional patent applications, especially if you watch Shark Tank. It's provisional patent is sort of I would call it a quick and dirty patent application to get to a filing date in the patent office. And you have to submit, a pretty detailed specification of how what you're protecting. And then it gets you, it locks down that date as the early date with the patent office, right? But that never gets examined by the patent office. So within 1 year of filing a provisional application, you must file a non-provisional application. And this is the more complex patent. Some people will wait to file the non-provisional and file the provisional first because the provisional is more affordable. They want to see if it's worth it to invest in the non-application. They might want to sell the provisional application. get investors, do other things, and put their budget towards that as opposed to filing a provisional. So it's really a strategic decision that needs to be kind of worked out between a patent attorney and the inventor. But those are the different kinds of categories of patents that there are.
So Tina, for instance, if I sort of got a product and it was, you know, I wanted to make a relatively small change to, you know, say like that water bottle, the cap, and I've designed different type of, you know, screw thread or something.
It doesn't have a straw. It has a screw cap or something. Yeah, okay.
So I could patent a particular thread or whatever.
Yeah. Yeah, things can be like different designs can be patented for the same thing. So different water bottles can have the same design. If there's a useful feature that's novel, then yes. Like if there's like a cap that you have a useful feature for, like it has some kind of seal or some kind of something that you think is useful, you've created that's novel about it, then certainly you can file a utility patent for that.
But obviously it's got to be worthwhile to do it because of the cost.
Yeah, I mean patents are not. Yeah, patents are not cheap.
Yeah.
Design patents also, you can file both a design patent and a utility patent for something, and some people will file both if it's possible, because the design patent you get examined sooner than the utility patents. But yeah, I mean, it's not something to take on lightly. The price point of a patent is much higher than that of a trademark.
So what is the sort of cost of a patent? Approximate cost of a patent?
I mean, it really depends on the term you use, the technology area, the complexity of the invention. There's a lot of factors, but you're not going to find a provisional, a good provisional application that's less than $3,000 to $5,000. And a good non-provisional is probably not going to be less than 7 or 8, and you could go all the way up to 15 or 20. And that's $1,000. In a patent application. So that's what you're looking at.
How long would does it take, the process take to patent something? Is it a long drawn out process?
I'm sorry, you cut out a little bit.
How long does the process?
Over a year. I think it's at over a year right now before anybody looks at it.
Yeah. So it's a bit of a long drawn out.
So you have to be ready to. It's a little bit long. So if it's a product that's going to go obsolete, or it's not something that you're, and here's my thing with all intellectual property. If you're just getting it, the certificate on the wall, it's not worth it. If you're getting it to have an asset that you're going to sell, if you're getting it to add value in your investment, if you're getting it to go after infringers and to figure out license deals or something that generates a profit for you, great. If you're doing it because you want the pretty certificate, use your money for a better thing.
Yeah, totally agree. For sure.
I mean, it's not something you're cheap. So.
That's right. Yeah.
Does it get tricky if, just say I've got, I don't know, a jug and it's got, say, a round handle on the side and I make it square? Can I token, like, is that enough difference for it not to be copying someone else's patent? How do you, I find that really hard to distinguish. Like, where do you draw the line in the sand?
You're going to hate this answer, but I'm going to say it depends. It's one of those things where if it's a utility patent, it depends on the claims and what they're actually, what they say is, they're claiming as meets and bounds of their invention. And if it's a design patent, there's no percentage. There's no, if you have a 30% change, then I've heard that more times than I can count. It's not an easy analysis. It's something that, sophisticated companies hire us to draft freedom to operate opinion letters to make sure that they're not going to infringe somebody's patent. And the reason we have really, really expensive liability insurance is so that we can write those opinions. so it's one of those things. It's risky, and you need to, it's not a very easy answer, which is why I have to give a very ambiguous, it just depends on what you change, how much you change it, what the claims are, how complex the patent is, how weak the patent is, how strong the patent is. I mean, all of those things make friends in that analysis.
Yeah. So can I also patent a pattern? So let's say I have, maybe a cushion cover or a bedspread, and I've come up with a very unique pattern for it. Is that patentable?
Megla, I don't know the answer to that question for sure. I think that you can. I know you can copyright it.
Okay.
Copyright is the other. There's three major buckets for IP intellectual property: patents, trademarks, copyrights. Patents protect the new, useful, non-obvious inventions. Trademarks protect source identification. Copyrights protect artistic design. They protect poetry. They protect songs. They protect music. They protect photos. All of those things. And so potentially a design would be more covered by copyright or pattern. And I'm not sure about patent. I feel like I don't want to say for sure because I read something, and so I'm concerned about giving the wrong answer. But I can revert back to you with that answer if you want, Megla, and you can post it later if you want.
Okay. Yeah, I guess it makes sense to copyright it because it's more of a, it's not text, but yeah, it's content, I guess.
And then I would say that, I know you could copyright it. My problem is I'm wondering whether you could do a design patent for it. And I just don't remember. You could also do a trademark for it, right? So patterns, if you've seen the Louis Vuitton, the LV, that's just you see that pattern, that you'll see it on, of course I don't have it right now, but you'll see that design repeated over and over, the LV, the interlocking LV. If you have something like that, sometimes repeated pattern designs like that are considered trade dress and can be a trademark. So there's ways that you can protect it under trade dress as well. So there's different ways to skin that cat, and it would just require kind of looking it out from there.
Okay, sounds good. So guys, let us know if you have any other questions for Tina. We'll start wrapping up here. Post your questions in the comments. Mark, Kevin, do you have any other questions for Tina? Anything else that you wanted to ask? Oh, Kev, you're muted, sorry.
I think we've covered pretty much everything today, from patents to trademarks to design and word marks, and how to get brand registry on Amazon, which is, for a lot of people, that's the main thing they want to do, is just get their brand on Amazon, don't they?
Yeah.
I know. It hurts my intellectual property nerd heart that's the only reason people would want to do it. But yes, that is a big I believe in intellectual property, and so I want you to love it for other reasons.
We do,
you do you, everybody.
We do.
So before we let you go, Tina, I guess, okay, we've got one question from Pachi. When do sellers take up a patent in their journey?
As early as possible, if that's something that they want to do. So as soon as you make a public disclosure, you basically have 1 year to get a patent on file. So you don't have time to dawdle. If you wait longer than 1 year, then you're actually barred from filing a trademark, or from filing a patent, excuse me. So early, very early. Bless you.
Excuse me. Okay, so before we let you go, Tina, I guess one last question is, what are some of the common mistakes you see people making as far as, especially Amazon sellers? What are the mistakes that they make in terms of filing trademarks?
I mean, if they're using me, they're not making mistakes because I'm telling them. But if I think what I see someone coming to me with that concerns me, filing, coming to me with a trademark that's very generic, was very descriptive of the goods. Trademarks that use a design element that also have a letter in them. So if your design element has like the letter Q in a star or something like that, and then the mark is then qualitish or something like that, right? So then the literal element at the trademark office is Q qualitish, and then that would have to be your brand name, right? So don't put letters in your design element if we're going to file a design mark for you. Avoid descriptive marks. Do some just basic due diligence. If you Google the trademark that you want me to file for you and you see that someone else has it, then choose a new trademark. Go to the trademark office. It's a public registry, very easy for you to do some searching on your own and do some due diligence. Definitely do that. You're going to want, don't try not to use your surname in your trademark. Try not to use a geographical location in your trademark. All of those things are things that trigger rejections at the trademark office, and I would ask you to try to avoid if possible. But other than that, those are the biggest mistakes that I see in terms of trademark choice.
Right. Also, I think when, in the application, you've got to upload images of our product with the trademark on it. And you had advised to just use use my mobile phone to take pictures of the product. You don't need to use pretty pictures that are photoshopped and, your Amazon pictures. You should not use those types. Can you explain a little bit about why that's important?
Yeah. So Amazon obviously sells. So you want to use your beautiful marketing shop, right? For the trademark office, there's actually a huge uptick in fraudulent applications. And so the trademark office is very picky about the specimen that prove your use in commerce. When we prove your use in commerce, we submit a picture of your goods to the trademark office to show your trademark on the goods or services. If it comes up with any pixelation, any weirdness, we will reject that specimen and they have to respond. And every time we have to do an action, we have to charge for that. And that gets costly and it's difficult. So my recommendation is just, go take your phone, your mobile phone, take a picture and, on your table outside in the bright light or on your kitchen counter. I don't care if the kid is standing in the background. I don't care if your cat walks by. I just want a good picture of your product where I can see the product, I can see the trademark on the product, and it doesn't look Photoshopped. It's not pixelated, none of that. It's Photoshopped away. I won't file it. I'm going to send it back to you. I'm going to say, I can't file this. They're going to say it's fraudulent, and I'm not going to be able to get it through. And that makes me cranky. So please, just picture one. It doesn't need to be fancy.
Okay, we've got one more question from Pachi. How do American and Australian spellings of the same word come into it? So, for example, honor and honor. Yeah, that's a great question.
Whatever you have on your product is the way I'm going to file it. So, if you use the mark honor HONOUR on your product, that's the way it's going to be filed. Trademark office doesn't care. I file marks in other languages all the time, so it doesn't matter as long as that's how it's used on your product.
Okay, so you need to decide how you want to file it, which I guess it depends on which market you're selling to. So you have to decide what spelling you want to use.
Yes and no. I mean, I think that most people, especially for that example, most people know how it sounds, and people do come up with marks that are, you can phonetically say in English, even though it's not really an English word. That happens all the time. Just or it's a word in another language. So I mean, there's no problem with doing that. The only thing is sometimes when I'm cutting it close on time. But the only thing is sometimes when you use a word in another language, let's say you use hola, which is hello in Spanish. The trademark office, there's something called the doctrine of foreign equivalence. So the trademark office asks for a translation, and then they search your mark based not only on the word hola, but also on the word hello. And so if there's a trademark hello for the same goods or services, even though you filed for hola, it's going to be cited against you, right? So I'm going to be searching your mark in every language. That doesn't really make sense in the honor situation, but if I do file a word that has a foreign translation, I am searching both the foreign translation, I'm searching the word, and I'm also searching the translation of the word in English.
Okay, that makes sense. Okay, Mark, Kevin, anything else from you before we sign off?
I just think Tina is a wealth of information.
Yeah, we covered A to Z today.
Good. I'm so glad this worked today. It was a pleasure talking to you guys. It's always fun on ISN. Your sellers are wonderful to work with. I love when I get inquiries from them because you guys know your stuff already. The education required for an ISN seller is like, oh, they already know. Megla's already talked to them. Marg's already talked to them. They've already come to me like, ooh, these are the easiest clients.
We're doing something right.
I love your sellers. I love working with you guys. So if there's anything that you ever need, I'm happy to answer any questions.
Fantastic.
And
Thanks.
just reach out to me, and hopefully I can help.
Yep.
Thank you very much, Tina.
Nice.
Thank you so much, Tina. And guys, thank you so much for joining us today. Don't forget, we have this tomorrow around the same time as today's session. So join us for this tomorrow. All right. Take care, everyone. Thanks,
Thank
Tina.
you.
Bye.
Thanks, Tina. Bye.